All right, Kristen, we are now recording, and I'll keep putting people in as they show up.
Thank you very much. Good morning, everyone. My name is Kristen Maughan, and I am the Housing Coordinator for the City of Tulsa. I am here today with Housing Solutions, the lead agency for Tulsa's Continuum of Care, a way home for Housing Solutions' mission is to make homelessness in Tulsa brief, rare, and non-recurring. Today, Housing Solutions in the City of Tulsa are presenting an overview of the CDC's eviction moratorium. The goal of this presentation will be to explain the agency's order that was published including what it does and who it applies to. This presentation will also provide resources for both landlords and tenants experiencing financial hardship due to the COVID-19 pandemic, including emergency rental assistance. We ask that during the presentation, all attendees please keep their cameras off and their microphones muted. We will answer questions at the end as time permits. If you have a question, please use the chat function to submit your questions. We will be sharing the PowerPoint presentation slides and additional resources by email to those who have registered for this event. As a brief note, this presentation will not be providing individual legal advice to landlords or to tenants. If you have questions about how the CDC eviction moratorium affects you personally or what your legal rights or obligations are under the moratorium, I strongly encourage you to consult with an attorney. Resources for legal advice will be included with the other resources identified at the end of this presentation. Right. So first of all, what the CDC eviction moratorium is. On September 1st, the CDC announced it was temporarily halting residential evictions to prevent the further spread of COVID-19. The CDC ordered that landlords would be prohibited from covered tenants from residential rental properties for non-payment of rent through December 31st, 2020. The notice was published in the Federal Register on September 4th, 2020. I've provided a link in the slide, so that is where you can view the order in its entirety online. In the order, the CDC states temporarily halting evictions is necessary as a public health measure to prevent the spread of COVID-19. The order states that a moratorium will allow people to self-isolate and assist state and local authorities with implementing stay-at-home and social distancing orders. The CDC also noted that housing stability helps protect public health because homelessness increases the likelihood of individuals moving into close quarters, congregate settings such as homeless shelters, which puts individuals at higher risk to COVID-19. The next slide, please. So can the CDC do this? The CDC cited two laws in its order to explain its authority for enacting the eviction moratorium. First is Section 361 of the Public Health Act. This allows regulations that are necessary to prevent the introduction, transmission, or spread of communicable diseases from foreign countries or between states. The second is 42 CFR 70.2, which authorizes the CDC director to take whatever measures the director finds reasonably necessary to stop the spread of communicable diseases if local public health officials have not been able to do so. The next slide, please. When does the moratorium begin? The moratorium began on September 4th, 2020, which was the day the order was published in the Federal Register. It will continue until December 31st, 2020. There is no provision that grandfathers in evictions that were pending at the time of the CDC's order. It applies to evictions that were filed and still pending on September 4th, 2020, and we'll see why in the next couple of slides. This means any pending eviction, even if it was continued, is affected by the moratorium. Slide 5, or I'm sorry, next slide. The eviction moratorium prohibits a landlord, owner, or other person with a legal right to bring an eviction or possessory action from removing a covered tenant for non-payment of rent before December 31st, 2020. So it does not relieve tenants of the obligation to pay rent. Tenants who are able to pay their full amount of rent every month must continue to do so. Those tenants who are not able to pay their full amount of rent should make partial payments to the best of their abilities. For those who make partial payments or are unable to make any payments at all, the rent is not canceled. That means the amount owed will continue to accumulate, but a landlord cannot file an eviction for the non-payment of rent. The order also does not prohibit late fees or other charges for non-payment of rent. If a tenant is paying rent late or is not paying at all, the landlord can charge tenants within the limits of Oklahoma state law. However, a landlord cannot file an eviction for failing to pay those late fees or other charges related to the non-payment of rent. Next slide, please. In its order, the CDC defines the term evict and eviction to include any action by a landlord, owner of a residential property, or other person with the legal right to pursue an eviction to remove or cause the removal of a covered person from a residential property. The only exception that is given is if the removal of the tenant is due to foreclosure on a home mortgage. It applies to any action that would remove or cause a covered tenant to be removed. It includes any legal attempts to evict a tenant for non-payment of rent, including serving a notice to vacate for non-payment of rent, filing a forcible entry and detainer action, also known as an eviction, for non-payment of rent, and obtaining or executing a writ to remove a covered tenant from the rental property. Any action also includes all attempts to evict a tenant for non-payment of rent outside of the legal process, such as locking a tenant out, shutting off utilities, or harassing a tenant to force them to vacate the property. Unlawful attempts to remove a tenant, such as locking a tenant out and shutting off utilities, violate the CDC eviction moratorium, as well as the Oklahoma Residential Landlord and Tenant Act. Landlords who engage in unlawful attempts to remove a tenant could be subject to civil penalties under the Oklahoma Residential Landlord Tenant Act, as well as the criminal penalties under the CDC eviction moratorium. For more information on illegal evictions, you can visit the Away Home for Tulsa website at awh4t.org, which has a recorded webinar on illegal evictions. Next slide, please. The CDC order lists 5 exceptions for when a landlord may file an eviction. These are the only exceptions for filing an eviction. The first 3 are engaging in criminal activity while on the premises, threatening the health or safety of other residents, and damaging or posing an immediate and significant risk of damage to property. This language is similar to an eviction under the Oklahoma Residential Landlord Tenant Act, Section 132D, which states any criminal activity that threatens the health, safety, or right of peaceful enjoyment of the premises by other tenants, committed by a tenant or by any member of the tenant's household, or any guest or other person under the tenant's control, or is a danger to the premises, and any drug-related criminal activity on or near the premises by the tenant, or by any members of the tenant's household, or any guest or other person under the tenant's control, shall be grounds for immediate termination of the lease. So this means that criminal activity exception is still available with the CDC eviction moratorium, but those landlords who've used it know that it is very narrow. A landlord may also evict a tenant for violating an applicable code or regulation relating to health and safety, or violating any other duty under the lease, other than the timely payment of rent or similar housing-related payment. This means a landlord may still file an eviction if the tenant is breaching the lease. 2 important notes on these exceptions. First, tenants must still meet their obligations under the lease during the CDC eviction moratorium. If the tenant violates the lease, then there may be the risk of eviction despite the moratorium. Second, while landlords can evict tenants for breach of the lease, they must still follow the legal procedure under the Oklahoma Residential Landlord Tenant Act, which includes proper notice where required. It does not permit a landlord to engage in the unlawful removal of a tenant, such as locking them out, even if the tenant breached the lease. Next slide, please. What properties does the eviction moratorium apply to? The eviction moratorium applies to all residential rental properties. This includes public, subsidized, and private rental properties. As you may remember, the CARES Act eviction moratorium applied only to residential rental properties with federally backed mortgages or participating in federally subsidized rental assistance programs, such as Section 8 housing choice vouchers. The CDC eviction moratorium is not limited to those properties covered by the CARES Act. That is because the CDC eviction moratorium applies to the tenant and not the residential rental property where they reside. If the tenant is covered, then the eviction moratorium applies. Next slide, please. So when is a tenant covered? To be covered by the CDC eviction moratorium, the tenant must meet the following 5 requirements. First, they must be unable to pay full rent due to financial hardship. They must meet income requirements. They must be making their best effort to make partial payments. They must be making their best effort to obtain government assistance for housing and rent. And they cannot have other available housing. So first, I will be going through what each of these requirements mean, and then we will address what the tenant has to do to demonstrate they meet those requirements and be covered by the CDC eviction moratorium. Next slide, please. A tenant is covered if they are unable to pay the full amount of rent due to a substantial loss of household income, loss of compensable hourly work, loss of wages, a layoff, or extraordinary out-of-pocket medical expenses, which the order defines as medical expenses exceeding 7.5% of their income. Neither the financial hardship or the medical expenses have to be related to the COVID-19 pandemic. They could be completely unrelated and still meet this requirement. Next slide, please. The tenant must meet income requirements. A tenant is covered if they expect to earn no more than 99% in annual income for 2020 and no more than $198,000 if filing a joint tax return, or if they were not required to report any income in 2019 to the IRS, for example, if their sole source of income was supplemental security income, or if they received an economic impact payment under the CARES Act, also known as a stimulus check. A tenant will be covered if they meet just one of these requirements. Obviously, they are not required to meet all 3. Next slide, please. The tenant must be making their best effort to make timely partial payments as their circumstances allow. So the CDC's order does not require the tenant to provide any proof or documentation that the partial payment is the most they are able to pay, and it does not set a minimum amount for the tenant's partial payment. The order only requires that the tenant must, in good faith, make their best effort to make a partial payment as their circumstances permit. If the tenant's circumstances do not permit them to make timely partial payments despite their best effort to do so, they can still meet this requirement to be covered under the CDC's eviction moratorium. Next slide, please. The tenant must be making their best effort to obtain government assistance for rent or housing. This requirement is limited to government assistance and does not include private rental assistance, though tenants are encouraged to reach out to any private assistance that might be available for rent or housing. 2 ways that the tenants can make their best effort is by applying for the state of Oklahoma and Tulsa County CARES Act funded emergency rental assistance, or by calling 211 to find out about other available assistance programs. We'll talk more about these resources later in the presentation. Next slide, please. A tenant is covered if an eviction would make the tenant homeless or force them into a congregate or shared living setting because the has no other available housing. A congregate living situation is a group living situation, such as a homeless shelter, and a shared living situation would be moving in with another household or doubling up. For housing to be considered available, the CDC agency order says it must meet 3 requirements. First, it must be unoccupied, so it won't result in a shared living situation. Second, it must be safe. Housing is not considered available unless it meets the minimum health and safety requirements for residential housing. Third, it cannot result in an overall increase of the tenant's housing cost. If the housing is unoccupied and safe but would increase the tenant's monthly housing costs, then it is not considered available under the definition of available housing in the CDC's agency order. So to summarize, the tenant must meet 5 requirements to be covered under the CDC's eviction moratorium. 1, the tenant must be unable to pay full rent due to financial hardship, even if the financial hardship is not related to COVID-19. The tenant must be below the income eligibility requirements. The tenant must be making their best effort to make timely partial payments as their circumstances allow. The tenant must be making their best effort to obtain any available government assistance for rent or housing. And finally, an eviction would make the tenant homeless or force them into a congregate or shared living arrangement because they have no other available housing, meaning housing that is unoccupied, safe, and would not increase their overall housing costs. So now that we've gone over when a tenant is covered, we will address what a tenant must do to notify their landlord that they are covered by the CDC eviction moratorium. And that is that a tenant must complete a declaration. The tenant must complete a declaration form attesting that they meet the criteria of the CDC's eviction moratorium. The declaration must be signed under oath and under penalty of perjury. The tenant must give a copy of the declaration to the landlord or property manager and keep a copy for their records. Under the Oklahoma Residential Landlord-Tenant Act, landlords are required to give tenants the name and address of the person who receives notices for the property in writing. Tenants should give the declaration to the person identified in that writing by the landlord. If you are a landlord and the person who receives notices for a rental property has changed, I'd encourage you to notify your tenants in writing of the correct person the declaration and other notices should be sent to. Copies of the declaration are available online at the Away Home for Tulsa website, awh4t.org. The CDC's agency order does not require any showing or documentation other than the declaration. For example, the CDC's agency order does not require a tenant to provide the landlord with documentation of financial hardship or reduced wages. But again, the declaration must be signed under oath, and it would be perjury for a tenant to sign the declaration in bad faith, declaring it applies to them if the tenant knows it does not. Next slide, please. The CDC's agency order states that there are criminal penalties for landlords who violate the eviction moratorium and remove a covered tenant for non-payment of rent before December 31st, 2020. The violations are prosecuted by the United States Department of Justice. Next slide, please. There are penalties for individual landlords and penalties for organizations such as corporations. An individual landlord violating the CDC's eviction moratorium can receive a fine of up to $100,000, 1 year in jail, or both. If the removal of the covered tenant in violation of the agency's order results in a death, then the fine may be increased to up to $250,000. And in a organization landlord violating the CDC's eviction moratorium can receive a fine of up to $200,000 per violation. If the removal of the covered tenant in violation of the agency's order results in a death, then the fine may be increased to up to $500,000. Next slide, please. So now that we've gone over what the CDC eviction moratorium is, who's covered, we will talk about what the resources are for landlords and tenants. While the CDC's eviction moratorium temporarily halts evictions for non-payment of rent, it does not provide any additional resources, such as rental assistance, to relieve the financial hardship of landlords and tenants during the COVID-19 pandemic. So next, we'll review the existing local resources that are available in 3 areas: rental assistance, mediation, and legal advice and representation. First, rental assistance is available. For landlords, rental assistance will help relieve the loss of rental income that is causing many landlords to struggle to pay their own bills during this crisis. And for tenants, it will meet the requirement under the CDC eviction moratorium that they make their best effort to obtain any available government assistance for housing and rent. It will also help tenants avoid accumulating a large amount of unpaid rent during the moratorium. As I explained earlier, the CDC eviction moratorium does not cancel rent. Any missed payments will still be owed, even if a tenant cannot be evicted for it. Rental assistance can pay the past due rent, so the tenant will not be left with a large debt at the end of December. One way to apply for rental assistance is through the Tulsa Housing Authority's application portal at tulsahousing.nanmckay.com or by calling 918-236-0949. Through this application portal, landlords and tenants can submit applications for emergency rental assistance through the state of Oklahoma and Tulsa County's CARES Act funds. We'll discuss those emergency rental assistance programs more in the next slides. There are additional rental assistance programs available. To learn about those, landlords and tenants should call 211, or tenants can complete a request for housing assistance on the CSC Tulsa website. Next slide, please. The state of Oklahoma has allocated $10 million of its CARES Act funds to be used for emergency rental assistance throughout the state. To administer the funds, the state of Oklahoma has partnered with Restore Hope. Restore Hope is administering the funds for the following counties: Tulsa, Creek, Okmulgee, Okfuskee, Pawnee, Rogers, Mays, Washington, Nowata, and Osage counties. So if you have tenants if you are a tenant or you're a landlord with tenants who could qualify for Oklahoma emergency rental assistance, then you would apply to Restore Hope through the THA portal, which we'll talk a little more about later. Qualifying households may receive up to $3,600 in assistance, and the assistance is paid directly to the landlord. Next slide, please. All right, to be eligible, a household must have experienced financial hardship due to COVID-19. This includes job loss, reduced wages, or reduced compensable hours. There is also an income eligibility requirement. To qualify for emergency rental assistance from the state of Oklahoma, the household must have a yearly income below 80% of the average median income for Tulsa County. Every year, HUD determines the average median income for regions and publishes them online. The average median income is adjusted for family size. So on this slide, you'll see a chart showing what 80% of the average median income is in Tulsa. For example, 80% of the average median income for a family of 4 is $54,900 in Tulsa County. If a family earns below that amount a year and has experienced financial hardship due to COVID-19, then they may be eligible for emergency rental assistance from the state of Oklahoma. Next slide. Documentation will be required from both the landlord and the tenant to complete the application. This includes a copy of the lease, a notice showing the rent is late, a ledger showing the amount of rent owed, and a statement from the tenant that their financial hardship is due to the COVID-19 pandemic. Previously, tenants were required to provide an eviction filing through a forcible entry and detainer case number. That is no longer the case. An eviction does not need to be filed to qualify for Oklahoma emergency rental assistance. Landlords are required to provide a W-9 for every rental assistance application. This is for IRS purposes. However, to simplify the process, landlords will be able to upload one W-9 to the application portal and attach application IDs to the W-9, so that rather than uploading a new W-9 every time a tenant files a rental assistance application, landlords are able to update the W-9 to include additional rental assistance applications. Next slide, please. Tulsa County has also allocated up to $15 million of its CARES Act funds to be used for emergency rental assistance. Tulsa County has partnered with the Tulsa Housing Authority, THA, to administer those funds. Households may be eligible for up to 3 months of past due rent for a maximum of $3,000. And again, assistance is paid directly to the landlord. Next slide, please. Both tenants and landlords will need to provide documentation to complete a Tulsa County emergency rental assistance application. If the tenant is filing the application, they will need to include a copy of the lease, contact information for the owner, landlord, or property manager, and documentation that the tenant has lost income due to the COVID-19 pandemic. Just like with the Oklahoma rental assistance process, landlords are required to provide a W-9 for every rental assistance application for IRS purposes, and are able to update the W-9 to include additional rental assistance applications filed after the W-9 was uploaded. Landlords must provide a letter stating that the tenant is behind on rent and that the amount is past due. However, in situations that a landlord might refuse to provide such a letter, then tenants will be able to self-certify and provide their own letter stating that they are behind on rent and the amount that is past due. Next slide, please. THA and Restore Hope have partnered with Nan McKay, a professional services organization serving the affordable housing industry, to administer this application process. Since August 24th, applications have been accepted online through tulsahousing.nanmckay.org and through the call center. The call center has a translation service, so applications can be made in multiple languages. When an application is submitted, it will be considered for both the Oklahoma and Tulsa County rental assistance programs. Approved applicants will receive rental assistance from the program they are eligible for, but cannot receive assistance from both the Oklahoma and Tulsa County programs. Once an application is made, the applicant will receive an ID number. This ID number can be used to attach necessary documents and check the status of the application online. Because both tenants and landlords will be required to provide documents for an application to be complete, including a copy of the lease, and landlords will also need to provide a W-9. Rental assistance for approved applications is paid directly to the landlord. Payments are already being issued by THA and Restore Hope. Currently, there is about a 2 to 3 week processing time from the date that the application is received to the date when the payment is issued. Payments are being issued as quickly as possible, but they may be delayed if there is a delay in uploading documents. So both tenants and landlords are encouraged to respond quickly. For more information on applications and the documents required, you can visit tulsahousing.nanmckay.org. Next slide, please. In addition to rental assistance, mediation is available to assist landlords and tenants. The Early Settlement Mediation Program, which is sponsored by Tulsa County and the Oklahoma Supreme Court, provides free mediation to resolve disagreements between tenants and landlords, including difficulty paying rent. A mediation is a meeting with a neutral third party to help the tenant and landlord resolve their disputes and come to an agreement that will benefit both of them. Early settlement mediators are trained and certified by the Oklahoma Supreme Court. The Early Settlement Mediation Program has a high rate of success. Through the Early Settlement Mediation Program, 75% of civil cases reach a settlement, and once settlements are reached, they stick. 94% of those settlements are successful, so that no further mediation or court action is necessary. If you are a landlord or property manager or a tenant that is interested in learning more about how you can use mediation, Housing Solutions in the City of Tulsa hosted a panel on mediation on Tuesday. A recording of that mediation will be available on the City of Tulsa's YouTube page and the Away Home for Tulsa website. Mediations can be conducted in person and virtually to ensure that everyone is able to remain safe during the COVID-19 pandemic. Both landlords and tenants are encouraged to apply for mediation as soon as a dispute develops. To apply, call 918-596-7786 or visit the Away Home for Tulsa website to get an application form and email it to susan.johnson@tulsacounty.org. A copy of the intake form will also be emailed to all those who registered for today's webinar. Next slide, please. As a landlord, you may have questions about how the CDC eviction moratorium affects you and could benefit from speaking with an attorney for advice or possible representation. If you do not already have an attorney that you consult and work with, then you can call the Tulsa County Bar Association, which has a lawyer referral program. They can refer you to an attorney who will advise you on your rights, legal options, and if necessary, can arrange for future legal work and representation. To contact the TCBA Lawyer Referral Program, call 918-587-6014 or visit tulsabar.com. And if you have questions, I know I've given you a lot of phone numbers and a lot of web addresses to visit for applications. We will again be emailing out these slides to everyone who's registered for the event. Thank you. So as a tenant, you may have questions about whether you are covered by the CDC eviction moratorium. There are 3 ways to request free legal advice or representation. First is to call 211 or visit csctulsa.org/211-EOK to see available legal resources. Second, apply for assistance from Legal Aid Services of Oklahoma by calling 888-534-5243 or in Tulsa 918-428-4357. You can also apply online at www.oklegalconnect.org. For women in North Tulsa, Still She Rises also provides legal advice and representation. And for assistance from Still She Rises, call 918-392-0867 or visit stillsherises.org. If you are a tenant who has been served with a summons, it is important that you go to your hearing. Do not miss your court date or a default judgment will be entered against you and you will be evicted even if you are covered by the CDC eviction moratorium. Attorneys are available at the Tulsa County Family Juvenile Justice Center, where eviction hearings are currently being held. And they can provide you with legal advice and representation in your hearing, as well as copies of the declaration for the CDC eviction moratorium, and also help you apply for rental assistance. And that is the last slide. So if anyone has any questions, please enter them in the chat and we will answer them as best we can.
Kristen, we currently don't have any questions at this time.
Well, that's good.
One just popped up.
What free legal assistance is available for landlords? Currently, Legal Aid and Still She Rises do not provide free representation to landlords. If landlords are in need of assistance, I would encourage them to contact TCBA. They, in addition to having a lawyer referral service, also do have a pro bono program. I don't know whether the TCPA pro bono program serves landlords, but that would be the other option.
Kristen, this is Jeff at Restore Hope.
Yes.
I would also say that mediation probably would be a good option for those cases, and it's free, I would imagine. So for landlords and tenants to use that. I would also, just to clarify, for the state CARES Act funds, if you're in Tulsa County, you should use that portal. If you're outside of Tulsa County, the tenants need to become clients of Oklahoma or Legal Aid Services of Oklahoma, and they can do so through oklegalconnect.org, and then Legal Aid will refer those clients for funding to us. So they become clients of Legal Aid. Legal Aid has the right from the state to help the other 75 counties outside of Tulsa and Oklahoma County. So they need to go through legal aid first, but then the funding for those counties that you mentioned, Kristen, will come to us.
Great. And I should also say, since you mentioned Oklahoma County, in Oklahoma County, Community Cares Partners is administering the emergency rental assistance for the state of Oklahoma in that county. So if you have multiple properties or are an organization that serves multiple counties, for Oklahoma City and Oklahoma County, that will be the agency you contact. And they have their own online application process. Question, is there protections for tenants that apply from retaliation or threats? Well, any retaliation or threats that remove a covered tenant from the property, that would constitute any action. So again, any action that removes a covered tenant from the property violates the order. That would include harassing or forcing them to leave outside of the legal process. So this next question is one I would encourage someone to consult with an attorney regarding. We were asked, if you're buying a property that is currently rented and planning to move into it as the primary residence, if necessary, can we evict the tenant since we have no lease with them? I would encourage you to discuss that with your attorney or your realtor to see what your rights are as the purchaser with regards to the tenants. Any other questions that we can answer? Does the moratorium have any effect on the term of the lease, or is the tenant still required to move out when the lease expires? So the moratorium does not relieve tenants of their obligations under the lease. So as a tenant, you still are required to pay rent. You're still required to follow all the provisions. You're still required to follow the term of the lease. So if you violate or breach the lease in any way, that is an exception to the moratorium. The only thing that you can't be evicted for is non-payment of rent or non-payment of any late fees or charges related to non-payment or late payment of rent. Any other questions? All right. Well, thank you everyone for joining us today, and thank you to everyone who registered. So we have been recording this presentation, and we will make it available online on the Away Home for Tulsa website. We will also be sending out a follow-up email that will include some of the resources that we've talked about. For example, the intake form for the early settlement mediation program. And thank you everyone for joining us today. Have a nice day.